Hello, everyone. Just a brief word to start off this panel. My name is Bill Saunders. I am Senior Counsel with Americans United for Life here in D.C. I am the chairman of the Religious Liberties Practice Group, which is putting on this panel. So I want to say a word of welcome and to invite anyone who is an attorney who would like to join the practice group to see myself, get in touch with me or Dean Reuter about it. Now, the subject today, of course, has to do with the quote contraceptive mandate, and the Federal Society has done a lot of programming on that. We've done a number of podcasts, and they're available on the Federalist Society webpage. So if we don't answer all the questions today from this panel, feel free to go listen into those. And they're like these kind of sessions where we have people with differing point of views that discuss some aspect of the litigation. But what I want to do now is just turn it over to Robert Barnes, who you all will know at least by name, as he's a Supreme Court reporter for the Washington Post, and he'll moderate the panel.
Thanks very much. It's a pleasure to be here. We're going to try to keep this fairly informal today, and I will leave time for your questions later on. Whenever I give one of these, I'm always reminded of something that Justice Scalia said to a bunch of lawyers who said, whenever a judge asks you a question, try to find a way to answer it, even if it's a hostile question, because it's the only time you can be sure he's actually listening to you. So we figure that will work the same way for your questions. I'm going to go very quickly through the bios of our speakers who know this subject extremely well. My job most of the time will be to get out of the way of them and let them talk among themselves and ask each other some questions too. So, and at halftime, I'm going to move to this side of the table just to show my neutrality. First, we have Elizabeth Wydra with the Constitutional Accountability Center. She is the center's chief counsel, and as some of you know, it is a group of preeminent constitutional scholars and historians, state and local government organizations they represent, as well as the League of Women Voters and the AARP. Next to her, we have Marty Lederman, who's a professor at the Georgetown University Law Center. He's former Deputy Assistant Attorney General in the Department of Justice's Office of Legal Counsel. He's the author of the Lederman Compromise in this case, which we'll let him explain later.
Just a coincidence that it's called that.
John Eastman is a professor at Chapman University School of Law and the former dean of that law school. He's the founding director of the Center for Constitutional Jurisprudence, which is a public interest law firm affiliated with the Claremont Institute. He is a former clerk to Justice Clarence Thomas. I'm told that he wrote all of his questions. And
only the good ones.
Last but not least, Kyle Duncan, who knows this subject extremely well. He is a lawyer now in private practice in D.C., but he previously served as the general counsel for the Becket Fund for Religious Liberty, which I would like to plug as a reporter. Did a great job of helping us keep track of all the many contraceptive cases that have been filed around the country. So that's a good source for those of you who want to know more about where all of this stands. I have a feeling that most of you know about this case, but I'm going to give just a brief rundown, and whatever mistakes I make, someone will correct me on, I feel sure, and then we'll get to the questions. So the Affordable Care Act provides for certain types of preventative health services for those who are in employment group health plans. And one of those services is that women should be covered for all FDA-approved contraceptive methods. Now, the regulations provided exemptions and accommodations. There's an exception for religious employers such as churches, and an accommodation for religious nonprofits that don't meet the religious employer exception. They are the subject of a different group of lawsuits that are working their way through the courts, and we can talk about them more, but that's not all what we're specifically going to talk about today. There's also an exception for businesses that employ fewer than 50 people, and there is a temporary exemption for companies whose plans are grandfathered in. So the challenge that the Supreme Court heard in March came from two family-owned, closely held for-profit corporations, Hobby Lobby, a national chain of arts and crafts stores that employ at least 35,000 people. The number kept changing during this litigation, but I think I'm safe with at least 13,000. And Conestoga Wood, a much smaller company owned by a Mennonite family in Pennsylvania that makes cabinets and other things. They say that the requirement that they provide coverage for emergency contraception and IUDs violate their religious rights under the Free Exercise Clause and the Religious Freedom Restoration Act. This challenge comes under RFRA, which Congress passed in 1993. RFRA says government shall not, quote, substantially burden a person's exercise of religion, close quote. If a person can show a practice does that, the government must show its action is narrowly tailored to achieve compelling interests on the government. The owners, corporations, say that providing coverage of these types of contraception violate their religions because they consider them to be abortifacients. They say RFRA covers them, and thus the government's requirement is subjected to strict scrutiny. Government says RFRA was never meant to cover for-profit corporations, and it says that the neutrally applied requirement doesn't burden the owners, only the corporations they formed. Decisions made between women and their doctors have no impact on the Greens and the Hans, the two families that brought the challenges, according to the government. So let's start at the beginning, and I'm gonna sit down in a second, and I think we're gonna stay seated so that we can make this a little more informal and just talk. So the first question is for Kyle. Justice Ginsburg noted at oral arguments that RFRA was passed overwhelmingly with support from both liberals and conservatives. She said that never would have happened if anyone had understood that the law would allow a private corporation that employs thousands of people to decide that it could opt out of some requirements of a neutral law. You weren't there to answer her, but I'm sure you have one.
Right, thanks, Bob, and thanks to the Federalist Society for inviting me to be on this panel. So when RFRA was passed in 1993, there was this wide bipartisan agreement, and look, I don't think it's controversial to say it's because everybody on right and left agreed that religious liberty is a good thing, but maybe when you actually see how this principle works out in specific situations, some people sort of peel off and say, well, maybe it wasn't such a good thing. I don't think that's a particularly controversial proposition. I don't think it's a proposition that works against RFRA applying in this case. Sometimes general laws that one passes that are very broadly worded and powerfully worded the way RFRA is apply in down the road in future cases in ways that some of the original supporters think, oh, gee, I wish I hadn't done that. But the fact of the matter is they did that. They passed those words. Congress passed them, and they have meaning. I don't think that Justice Ginsburg or anybody else could point to any evidence during the run-up to RFRA that had someone saying, this is a great law, but I really hope that it doesn't apply to businesses who employ too many people, because that would be bad. Certainly, we would expect to see some kind of carve out in RFRA if that's what it actually meant. You might have expected to see a carve out the way you do in a law like Title VII that actually specifies that it only applies to certain religious corporations or other kind of specific entities. So you don't see that in the text of RFRA. The other thing that one might have said to Justice Ginsburg is that when you look at the legislative history that actually goes past RFRA, so when Congress was considering subsequent laws like the RLPA and the RLUPIA, and I'm not even I'll get the acronym wrong if I try to say what it is. So subsequent religious liberty laws, Doug Laycock laid out very beautifully in his amicus brief that you see very clearly in the discussions in Congress that people did in fact mean for RFRA to apply to commercial businesses, to incorporated businesses, to for-profit businesses. And this is very, very clear. Now, it is true that maybe when people were sitting around thinking about this, what they were thinking about was the kosher butcher, the paradigmatic example, the halal butcher who is running a for-profit business and who obviously is exercising religion in that business. It's probably true that nobody sat around and said, yeah, and it'll also apply to Hobby Lobby. But the fact is there's no real neutral objective principle that distinguishes the incorporated kosher butcher or halal butcher from Hobby Lobby. It's too big. I mean, that's just not a principle that I think that a court can reliably impose. So I think the bottom line is that RFRA says what it says. There's no indication that it wasn't meant to apply to commercial businesses or profit-making businesses or incorporated businesses. And the arguments against it applying either fly directly in the face of the text of RFRA, can draw on no precedent from Supreme Court cases that would exclude those kind of entities. And the other thing would lead to just flatly absurd results, which I hope we'll get into at some point.
Well, Elizabeth, there's no precedent either way on this, right, on this question? So I'm wondering what you think.
Yeah, I mean, I think that you don't have to look very far for evidence that it wasn't supposed to, that RFRA wasn't intended to apply to secular, commercial, corporate entities, because in the very title of the act, we see that Congress was intending to restore free exercise law. And never in the more than 200 years of First Amendment free exercise law has the free exercise right been understood to apply to a for-profit artificial corporate entity like Hobby Lobby. It's always been understood to be a personal right, a right of conscience, a personal dignity, something that an artificial corporate entity simply does not share in. Now, of course, there is precedent for individual sole proprietors who are running a business outside of the corporate form to bring a claim. Those claims generally fail, but I'm sure we'll get to that question again. But with respect to the threshold question of whether Hobby Lobby, as an artificial corporate entity, can bring a free exercise claim under RFRA, there's absolutely no support in the Constitution's text or history for that right to be accorded. It's simply a personal right of conscience that artificial corporate entities just don't share in.
John, didn't you think that that's what Congress was doing when it passed RFRA?
Well, it clearly was. And look, they were trying to restore the 200-year-old understanding of what the Free Exercise Clause did. And quite frankly, it's becoming increasingly clear that Justice Scalia in Employment Division versus Smith got this very fundamental premise wrong. That the First Amendment was not there to protect only those religions that could get their accommodation through the majoritarian process. In fact, it was there to protect religions that could not get their accommodations through the majoritarian process. And restoring that heightened scrutiny on things that burden religious exercise, whether by individuals or individuals who have come together to act collectively, through a corporate form or whatever. I remind people that all of the property owned by the Catholic Church is owned by the bishop as corporate sole. The corporation of presiding bishops of Church of Jesus Christ of Latter-day Saints versus Amos is a Establishment Clause case. The flip side of this, dealing with corporations. In fact, all of those Establishment Clause cases that deal with corporations on the other side operate under the premise that the corporation is exercising religion. Otherwise, there couldn't possibly have been an Establishment Clause challenge in the first place. So the notion that this is somehow brand new, that we've hit on this notion that, well, we ought to extend something that never existed before to corporations is just not true. And there's no evidence that RFRA was trying to limit it to only individual things, given that long history to the contrary.
Marty, the Greens paid for this kind of coverage before this law was passed, and said that they changed their policy when they found out that they were covering this. Does that factor into this idea of whether their religious liberty has been offended?
Oh, okay. Well, before I answer that, two things. One, I want to talk for a moment about the corporate question. But before I even do that, I just want to thank the Federalist Society. This is always I love being invited to these events. They're invariably among the most dynamic and intellectually enriching and interesting events in town. And it's great to see you all here. In fact, this is extra special because my placard here, I think this means I'm now an honorary member of the Federalist Society. So I'm going to put this up in my office, and a couple people in the audience might remember this. When I went into the Department of Justice in 2009, my office as Deputy Assistant Attorney General was the office formerly occupied by John Yoo, and on the wall there was a huge, huge photograph portrait of Justice Scalia looking right down onto my desk, and larger than life, if you can imagine that, if that's possible, right? Much larger than life, and I was sort of honored by that. He was keeping me honest every day as I did that, but then I bequeathed it to Nate Forrester, who asked for it, so I hope you're keeping it in good stead, Nate.
I think that actually expires at 12:15, but go ahead.
Oh, well, I'm going to take it before that happens. So let me, something on the corporate question, then Bob's question sort of segues into the substantial burden question. I think that this is something of a feint or a red herring, the whole question of corporate free exercise. It's dominated the public discourse on most of the briefs, certainly the lower court decisions in these cases, but I do think that it's not really the important issue here in this respect. I don't know whether for-profit corporations can ever exercise religion. Possibly they can. I do think that clearly people can exercise religion in the corporate form, through the corporate form, either as shareholders or directors or employees or employers of various kinds. I don't think corporations can exercise religion in the way at issue in this case. The claim here is that the federal law has basically mandated that someone violate religious obligations. Well, one thing I'm sure of is no religion imposes any obligations on Hobby Lobby, Inc. That kind of religious liberty claim isn't one a corporation can bring. On the other hand, as I've written, I do think that the Greens and the Hans, not so much as shareholders, something we can get into but is very arcane and off point, but as directors of these corporations, certainly do perceive themselves to be exercising religion through the corporations, and I expect that the court will hold, if it doesn't hold that the corporations can exercise religion, will hold that the Greens and the Hans can. The important question, I think, is on the merits. And that's where the history really comes in, and on that I agree with Elizabeth, that to the extent RFRA was restoring the law, I agree it wasn't excluding certain sorts of entities when Congress did so, but it was trying to incorporate the corpus of doctrine of the Supreme Court's free exercise doctrine. And what's really striking about that is that in the commercial sector, corporate or non-corporate, profit or non-profit, virtually without exception, Hosanna Tabor being an exception recently that we can talk about, every case in the Supreme Court's history from 1944 through 1989 involving the corporate sector, the court denied a religious exemption under the free exercise clause for people acting in the commercial sector where that exception would burden fellow employees, customers, or competitors. And not only that, there were virtually no votes. It's virtually 9-0 in each of the 9 or 10 cases involving that. And so it's the merits, I think. I don't think Congress could have contemplated that there would be a successful RFRA claim. I agree that they contemplated there might be a RFRA claim, but not one that could possibly get votes. And that's why this is so fascinating. It's clear that there are at least some votes on the court on the merits for these, for the Greens or the Hans at least. And I think that will be a sea change in the court's doctrine with respect to free exercise if there's a majority for that. Now, Bob, as your...
Well, let me
Okay,
stop you just for 1 second.
Yeah.
Because I would say that all of the reporters who left the hearing that day seemed to believe that there were enough votes on the court that this would go through and that this threshold question was not going to stop this challenge. Does anyone disagree with that? Or do you think the reporters got it right? Elizabeth?
Well, far be it from me to say that the reporters got it wrong. I'm sure you were all right. I was really interested that Chief Justice Roberts didn't ask more questions about the corporate law implications of the threshold question. I think that the fact that the business community did not come out in full force in support of the corporate plaintiffs in these cases I thought was interesting, and there were certainly friend of the court briefs raising through corporate law scholars the possible Pandora's box that could be opened if you allowed a corporation to bring a free exercise claim like this, or even the owners, whether it's through some sort of shareholder standing rule or something like that. So, you know, I wonder when they're going back to write it if that will come up at all, or if that will just be sort of swept under the table. But, you know, I think that there's before we get off the threshold question of who can bring this claim, there's a Fifth Amendment self-incrimination clause case that I think is really helpful to understand the who can bring a claim question in this case. And it's called Braswell versus United States. And it's about an individual who had a closely held business, and he was served a subpoena in his official capacity as an agent of Braswell Enterprises, which shared his name. And he tried to interpose a Fifth Amendment self-incrimination objection to these corporate documents that were subpoenaed from him, because he said that they would be personally incriminating to himself, Randy Braswell, not to Braswell Enterprises. And the court said that there was a clear, long-established distinction between individuals, even when they're acting on, you know, as the closest possible agent of the corporation they could, and the artificial corporate entity itself. And so a lot of times we say, well, someone has to be able to bring this claim. And you heard that a lot at argument. I think that's why a lot of us left the argument thinking that, well, maybe they won't say that the corporation has the right, but the owners do, because they felt like someone must be able to bring this claim. But in Braswell, no one was able to bring the claim, because the court said that the corporation did not have a self-incrimination right, because that's a personal right of conscience that an artificial corporate entity does not have. And they said that the individual, Randy Braswell, didn't have the right, because the burden of the subpoena was on the corporation. Just as here you could say the burden of the Affordable Care Act goes to Hobby Lobby Inc. and not the individuals who are behind it. So I think that the reporters were right, and that was sort of my feeling coming out of it, that the court wanted someone to be able to bring this claim, even if it might, even if there were questions about whether it would lose on the merits. But I think under their own case law, they shouldn't come out that way.
Kyle, what do you think? Or John?
I mean, I think those cases are distinguishable. I mean, the Fifth Amendment right stands as an impediment to the judicial function of getting at the truth, and so it's always been narrowly interpreted. The free exercise right taps into a natural right that we all have, freedom of conscience, and it's always been broadly interpreted. It's not something you exercise in your individual capacity, and you can, and you have individual conscience, but it has tended to be something that you also exercise collectively, and that's why many of the religious organizations are themselves in the corporate form, and you've got the church itself, which is a corporation, and then you've got the entities that the church runs, nonprofits, which are often corporations, Catholic Charities, what have you, and there's no distinction in First Amendment jurisprudence to distinguish between those that run the church and the altar itself versus the things that do other parts of the church's mission versus the broadly interpreted understanding of our freedom of conscience would suggest exactly the opposite. And it goes back, I mean, I think there's a broader problem here. And, one of the descriptions on our panel is, how has religion in society changed since the time of the founding? Well, the notion that we could compel people to act in all sorts of ways that violated their religious belief, and they wouldn't have an exemption from that, was a much narrower set of things at the time of the founding. You could not act in furtherance of your religious belief to things that threatened the public safety or the public good. But the notion that it was all generally applicable laws, that's something new. And the scope of government in imposing those generally applicable laws and the conflict with religion is entirely new. So I think RFRA tried to recarve that space for freedom of conscience in its full implementation, and in that sense get back to a lot more to what the founding was. And like I say, where on that infinite continuum of corporate structure the line to be drawn just doesn't exist anywhere in the text or the history of it.
A couple of things, Bob, just to respond to what Elizabeth said and then to respond to something that Marty said. So I don't think the government in the Supreme Court could have relied on that Fifth Amendment precedent about self-incrimination, because the government, as far as I can tell, admits that nonprofit corporations exercise religion in the form of churches and hospitals and charities. So the government, by its own argument, has admitted that the religious exercise right isn't a purely personal right. So they couldn't have made that argument even if they had wanted to. And so, I mean, I think the reporters, as always, got it right after the, with some exceptions.
I'm
but-
afraid we're out of time.
Yes, yes. It got it right. That, and just as an aside, it's amazing to me what little traction the government's profit makers can't exercise religion argument got in the Supreme Court. Because after all, as Marty pointed out, in the lower courts, we were told that corporations can't pray, corporations can't go to heaven. We were never told that corporations can't go to hell, I might add, but that they can't go to heaven or purgatory. So it was amazing to me what little traction that argument got in the Supreme Court, which was sort of made us feel good at the Beckett Fund, since that's what we were saying all along. The second point is the idea that vindicating the claim in this case would represent some kind of sea change, because it would be recognizing a substantial burden on someone's exercise that stemmed from requiring them to afford a benefit to an employee or to some third party. I'm not so sure it would be a sea change. We can talk about how United States versus Lee factors into this, because I think that's the most important precedent. But the other thing to note here is that this was I went back and reread the argument transcript recently. Justice Kennedy at one point, I think, asked the Solicitor General, now look, I'm paraphrasing, you've given a bunch of exemptions to churches, to other nonprofit religious organizations, or at least HHS gave a bunch of exemptions. Now, on what basis are you giving exemptions, if not your recognition that there is a genuine burden on the people who are running these corporations, a genuine burden imposed by asking them to give these benefits? In other words, are you giving them a RFRA exemption sort of silently under the table, or are you acting on the basis of some other calculation? And I don't remember hearing a convincing answer from the Solicitor General on that. I think it's a real weakness in the government's position here. I mean, the Lee case, for instance, involved claimed exemption from providing Social Security benefits, and the court has described that as a system where mandatory participation is indispensable to the way the system is supposed to work. And so you can understand the court's concern by saying, if we're going to grant sort of wholesale religious exemptions, we're really going to imperil the way the system's going to work, and we are effectively going to end up imposing the employer's religion on the employee. You can sort of understand that. Here, by contrast, you've got a system that is front-loaded for religious exemptions. I mean, you've got HHS empowered to grant some open-ended category of religious exemptions from the get-go. So it's in our mind, it was always difficult to draw that analogy between the Social Security system in Lee and the mandate system. So we never saw that as a big attack on Lee or a sea change in jurisprudence to recognize the exemption.
Yeah. Marty, do you agree with that? It is something that they got a lot of questions on. If there are all these other exemptions, then how compelling an interest of this is the government, and why doesn't the government just pay for it itself?
Well, I do want to note before we get off that, I think we have some consensus here, not just that the press is always right, that the court is very likely to rule that someone has standing or opportunity to sue. I think the justices, including the chief, were uneasy about saying that it's the corporation or the shareholders, because what about when you get a more complicated case with more shareholders? Mm-hmm. That's why I think the easier way to go is simply to say that the Greens and the Hans as directors are the ones whose religion is burdened here, or who allegedly burdened here. And as for Elizabeth, the Braswell case, I'd say the following. The single most important thing about the Braswell precedent, which the government did rely on, by the way, is that Justice Kennedy filed a vociferous dissent in the Bradwell case.
But he agreed with the premise behind it.
Okay, all right. I'm not predicting Justice Kennedy's vote for Braswell here. Now, we've moved or Kyle has moved us to what I think is one of the more interesting, but I think one of the most misunderstood parts of the merits on the case. And that is, well, what about these other exemptions? And I take it that will probably be the subject of most of our discussion here this morning, or good part of it anyway. And in particular, Kyle points out that HHS has granted 2 forms of exemptions to different sorts of religious organizations. And Justice Kennedy did ask the Solicitor General, well, why not extend at least the second one of those, what Bob described as the accommodation, which I can describe briefly in a second, although it's complicated. Why not extend that to for-profits? So nonprofit religious organizations don't have to the funding for the contraception doesn't come out of their pocketbook. They don't have to pay for it. It has to be paid instead by the insurer, like Aetna. Why not give that accommodation to for-profits as well? And the Solicitor General's response was, well, we haven't really looked at whether we have the statutory or financial ability to do that because the Beckett Fund and other plaintiffs here have consistently not asked for that because they think that would violate RFRA too. And so that's never been vetted. And I think one of the possible outcomes in the case, interestingly enough, is a remand. This was decided not only on a complaint, but at the PI, preliminary injunction stage. One of the themes that I've been trying to write is that these cases are all extraordinarily fact-intensive and very context-specific and shouldn't be decided in gross or at the PI stage or on the complaints, which are, by the way, very bare bones. Beckett, and I commend Kyle, I see Lori Wyndham in the audience here. Beckett really litigated these cases extraordinarily well and set up this issue that but they didn't raise this issue. They're not asking for that until at oral argument when it was really interesting that Paul Clement, on behalf of Hobby Lobbying in Conestoga, was he was reading the room correctly. The justices were enamored, at least Kennedy, who's clearly an important vote, was wondering, well, maybe that's the answer here, right? The government should be giving these for-profit corporations the same ability to have their insurers pay for it that the nonprofits have. Why? There's nothing in the statute that prevents that, probably. It's a complex multi-statute question. And so I think one possibility here is that the court remands it for trial or some sort of hearing on whether that would be a less restrictive alternative. I don't think the fact that the churches are exempt or that the nonprofit organizations are given the accommodation, the stronger argument Beckett made, which is that these exemptions demonstrate that the government doesn't have a compelling interest. That's a much weaker claim and one that we can discuss at length. I don't think that the so-called exceptions have undermined the government's interest in the slightest. In fact, it's still the case that under the law, virtually all women in America are entitled to get cost-free coverage for contraception, whether they get it from the government or from a plan on the exchange or from their employer. The single exception to that is women who join churches and their auxiliaries. And the theory behind that was that those employees understand that they are joining an organization that could be expected to not only discriminate on the basis of religion, but to expect their employees to comply with their religious tenets. So, but I do think on the narrow tailoring question, the existence of this secondary accommodation, the justices, I agree with Kyle, were very interested in why couldn't that be applied to the for-profit side.
Mm-hmm. Kyle, I think Paul Clement did find eventually a phrase in a filing below that he used to say, well, yeah, we did ask for this, but I don't know that the justices were completely convinced by that. Would that satisfy the Greens?
I think it's never come up, and as Marty said, it's certainly never been offered by HHS. I guess it's just never come up. But I mean, a couple of things, a number of things actually. So I don't read anything that Paul said during oral argument to say that the accommodation would be great for the Greens. I just don't read what he said to say that. In our briefing, and it wasn't just at the merits at the Supreme Court, but from the beginning, we always said that a less restrictive means would be for the government to pay for these things themselves as they do through Title X and other programs like that. And what we also said was, look, the fact, and I think the accommodation came up after the litigation was already underway, so it wasn't as if we could have taken that into account at the beginning. But what we said after the accommodation came up was, look, this shows that the government can sort of try to engineer some other way of getting these drugs to people. Now, the way they're doing it through the sign away your conscience form, like they're asking Little Sisters of the Poor to sign, is not a good way. right? They need to do better than
Well,
that.
what is a good way? I mean, what,
I've
I
nev-
don't know what would satisfy a group if that form doesn't satify them.
Well, I mean, don't make them authorize the flow of contraceptives to their own employees. I mean, do it the way the government does it in Title 10. I mean, do it through a genuinely separate mechanism. Don't make them participate in it themselves. I think the fact that the Supreme Court issued an injunction pending the appeal in Little Sisters of the Poor speaks volumes for what the Supreme Court thought about that form, since it said, okay, you're going to get an exemption and you don't have to fill out that form. But just back to something that Marty said earlier, the fact that the mandate is front-loaded for exemptions and HHS has given some exemptions. My main point in making that was not that those exemptions in and of themselves demonstrate that there's no compelling interest, although we think that they do demonstrate that. My point was a little bit more basic than that. When we got to the Supreme Court, the government shifted its compelling interest argument and said, we have a compelling interest in a comprehensive system of insurance benefits. And they cited United States versus Lee. Now, this is somewhat of a different argument. Before, they had been saying we have a compelling interest in sort of this wholesale public health idea and the gender equality idea. Then when it got to the Supreme Court, I like to think that the government looked at those and said, we've stated those so broadly that we can't possibly win. So we've got to come up with something with a little bit more teeth. And they had been relying on Lee all along, and they said, well, in Lee, what was really important was that the Social Security system had to be comprehensive with mandatory participation in order to work. So the government tried to shoehorn their compelling interest into the Lee system, and that's why we made the point that, well, wait a second. This mandate already is sort of structured to accommodate all sorts of exemptions. The government's given some, could give more, but it's already front-loaded for exemptions. It can't possibly be like Lee. So our argument was a little bit more sort of, it went to the core of the government's compelling interest. You can't, I think we said in the brief, I mean, it's like invoking a compelling interest in an impenetrable barrier and pointing to the sieve that you've constructed. Well, lots of stuff can get through the sieve. That doesn't further your interest at all in having this comprehensive system. That's the argument we were making.
John, at the hearing on the constitutionality of the Affordable Care Act, the conservative justices put a lot of pressure on the Solicitor General to talk about limiting principles and where would this end. There was a little bit of reverse of that at this hearing, in which the liberals were pressing for what is the limit here. Can a group that says vaccines violate their religious beliefs decide not to fund those, or blood transfusions? Where does it end? And Justice Kagan said it would end with so many exceptions to what people found objectionable that it would be piecemeal and it would not be a national plan at all. Can you respond to that?
Yeah, I would say, yeah, that's right. Maybe we ought to revisit the constitutionality of the Affordable Care Act decision itself.
Yeah, I think Justice Kennedy brought that up,
Yeah.
and there weren't any takers.
But look, I mean, Marty said something, because one of the pieces that I think is integral here that we've overlooked thus far is what is the burden on religion in the first place. And Marty said something about the goal of this statute was to provide cost-free contraceptives to women. Now, there's no such thing as cost-free contraceptives to women, and I think it highlights that somebody is being asked to pay for these services, whether
cost-free to the women.
To the women, all right. But that means somebody
That's
else.
the shorthand.
No, I know, but that means somebody else is being required to pay for it, to pay for something that is fundamentally contrary to their religious beliefs. That, I think, establishes and it wouldn't be whether it's. I think that would apply if it's vaccinations. I think it would apply to all sorts of things, particularly when you have the alternative of imposing a general tax. If this was within the constitutional authority of the federal government in the first place, to impose a general tax and then out of the general fund pay for whatever services the government decides to pay, rather than making the direct burden on those whose exercise of religion and freedom of conscience is going to be burdened by it. And that means I would have to answer Justice Kagan's question. Yeah, it would allow for a lot of those extensions as well. And there's always the alternative, if the government thinks it has the constitutional authority to general tax and then pay for these services out of that. That solves the religious objection, and it furthers the government goal.
John, why does that solve the religious objection? You're
Well,
still paying for it.
well, because it's not direct, and I think you've got to accept. I don't want my taxes being used because I oppose war. Well, I'm sorry. You know, the general application of taxes, when the government can then provide the service or the protection its own, rather than forcing you to take up the arm and shoot yourself. I mean, that's always been the distinction. It's why we have the long recognized exemption to mandatory military service. It's why the Constitution's oath clause gives an exemption for those who were scrupulous of taking oaths, of being able to ratify affirmation. It's the difference between the generalized policy, which everybody can be asked to contribute to, and forcing them to do something directly that violates their conscience.
You agree. I think that's right. There's not a single justice who would say that is a winning argument. But on Hobby Lobby's theory, the person who comes forward and says, my religion forbids me from paying taxes that are being used for the war effort would make out a substantial burden.
Now, I don't know, because they're not doing that directly.
But they say it violates their religion for them to pay the tax.
Yeah, no, but that's a generalized claim that we've never accepted. The particular, I'm going to make you arm the guy that's going to go over to Afghanistan, that would have always been a
That's right.
violation of
And
the
we're
religion
not
clause.
forcing the Hans or the Greens to use contraception.
No, but
to
we
know
are
that
forcing
contraception
them. We
is
are
being
forcing
used.
them directly to pay for it, rather than to contribute
No.
into a general fund.
No, we're not forcing. First of all, we're not forcing them. We'll get into that later. There's actually, I hope this doesn't end our session, but there is no contraceptive mandate. But even their choice to provide health care doesn't mean that they have to pay for it at all. In fact, on the government's view, they're paying less money.
In the
Well,
same way that a paycheck could be used
Right.
to
Let
pay
me-
for those
No, no, no,
services
let
that comes from the
Let me go
Hobby
ahead and let
Corporation.
Marty get that out so we can talk about that as well. The idea that, that they don't have to provide health care at all, or these
So
insurance
in the lower courts, virtually all the litigants, the federal government didn't say anything one way or the other about it, but all of the private litigants and all of the courts of appeals, I think, or virtually all of them, assumed that there was a legal requirement here for employers of a certain size to provide the preventive care services, only one of which is contraception, but all of the preventive care services. As it turns out, the law isn't that, and I think the justices uniformly agreed that there is no legal mandate to do so. Congress is given a choice here, and this is a much clearer choice than the one that she found that Congress had given with respect to the so-called individual mandate in the Sebelius case. Here, there's no doubt that employers can, and they won't be violating the law, they can decide, as many employers do, not to provide health insurance at all to their employees, in which case they won't have to provide contraceptive coverage. And that, I think, was made clear in the litigation and at the Supreme Court. And then the question becomes, and Ed Whalen has written quite eloquently on this at bench memos, and I've written on the other side of it, then the question becomes, well, if the government gave you this other alternative, which is stop providing health care to your employees, you're no longer paying for contraception on any theory, but maybe that will burden you too. It will, the corpus of federal law that governs taxes and the like with respect to employer plans will put such pressure on you to offer employee health insurance that in effect the government, even under the second option, which is just don't provide employee health care, is pressuring you to do so in a way that is substantial enough to impose a substantial burden on your, it's sort of pressuring you to do so, and once you do so, it has to include the contraception coverage. And I think that's a really hard and intricate question and very case specific. And it's one that got a lot of play in the court. They're like, how do we know that this is the sort of thing that's going to impose a huge burden on Hobby Lobby? If they drop their insurance, we don't know what would happen. And Paul Clement parried those questions quite well and basically said, well, look, we haven't had a chance to litigate that either. And I think this is the second issue where at least some of the justices seem to be hinting that maybe the right answer was to remand for a hearing on would it substantially pressure Hobby Lobby, Conestoga Wood, and Mardell to drop their health insurance plans. Now, what's really interesting in the last 2 weeks is, I forget the name of the group, S&P Capital did an extensive study that was covered in a lot of the newspapers, saying that, in fact, they expect that 90%, I forget whether it's 90% of employers or employers covering 90% of employee health insurance plans, will, in fact, stop providing health insurance. This is going to be economically not only feasible, but rational for most corporations in America in the next few years. I don't know whether that number is right or not. What I do know is that this is an incredibly company by company fact intensive question about what the incentives are. It's a very complex array of incentives, both for and against providing health care plans to your employees. And I think the answer might be very different as to one of the plaintiffs than it is to another. So that did seem to get a little bit of traction they didn't call it the Lederman alternative, though. I don't think, an oral argument, thank God. But yeah. But I think this is an issue going forward, is whether this alternative is a way out of the case, or at least to kick the decision to the Notre Dame Little Sisters cases.
So a few things there.
Let me throw one other thing out, and you can address all of this at one time, because I would like to hit what I thought were some of the high points of the argument. And so I'll throw this one out, and you can do it, and when it comes back, I'll throw another one out. And that is, Justice Kennedy seemed quite concerned about the right of the employees, and why should the employer make all health decisions for these employees, and why should that trump them? So let me throw that into the mix of things you want to...
Because we don't have enough out on the table.
Right. Let me just take that one last. Well, I'll take the employee question first, because what Justice Kennedy said is he asked, how should we think about employee rights here? Should we think about them in terms of, well, the employer's right just trumps if the employer has a religious objection? And the answer, as we've always said, is no. The employer's right doesn't simply trump, just like anybody with a religious claim doesn't just always win. That we've always said that any rights of the employees, which are obviously the government is going to bat for the rights of the employees here, the government saying we have a compelling interest in providing these drugs through the employer health insurance, you deal with that in the strict scrutiny part of the analysis. You do not deal with that under the is your religion substantially burdened. It simply makes no sense to say, well, your religion is not substantially burdened here because your employees have a statutory entitlement to the contraceptives. That doesn't make any sense. What makes sense is to say, yes, your religion is substantially burdened, but maybe the government can prove that it has a compelling interest in forcing you to provide access to the contraceptives through no copay insurance. I think that's the right answer, and I don't think the government has come anywhere close to sustaining its burden to show it has a compelling interest to do that. So that's the employee rights part. I'm sure we'll get back to it in a second.
Let me pick up on that real quick, because there was an email that went around the other day, and sometimes these things have the humor of them has a wonderful insight. It said, I've never understood the argument that it's my body, you have zero control over it, and yet I'm obligating you to pay for 100% of what I'm asking to do to it. Right? This goes to the heart of the question there. Who is being asked to pay for things, and shifting that conversation away from the employer is actually being asked to pay for something that is morally objectionable to the employer says nothing about the employer trying to direct the employee's activities that he or she might get on their own outside of what the employer is paying for.
Well, it was Congress who said that they have to do it, right?
Yeah.
Right.
So there, we're talking about when we're talking about the employee rights. We're talking about the employees have a right to these preventive services and the full range of FDA-approved contraception, which Congress and the experts to whom that authority was delegated have said are incredibly important to women's health. They have a statutory right to this sort of health coverage. And it's important, the government argues, because it helps by providing the full range of FDA-approved contraception, including, and I think it's important to note in the facts of the case, the objections raised in this case are not to every form of contraception, just to a small subset. But the government has an incredibly important interest in providing the full range of FDA-approved contraception, because it is, if the employee decides to take advantage of this, deciding that it's the best for her and her family to use contraception, And if she and her doctor decide that one of these covered forms is one of the best, safest, and most effective forms to prevent unintended pregnancies, then the evidence is clear that preventing those unintended pregnancies prevents profound economic and health concerns, detrimental concerns for women and their families across the country. And I think that, when we're talking about compelling interests, to think about the cases in which the court has held that the government has a compelling interest against a free exercise case, the Social Security taxes in Lee providing for retirement. In the Braunfield case, there was a governmental interest recognized as sufficiently important in preserving Sundays as an escape from the hectic tempo of everyday existence. If those are sufficiently compelling government interests, I think that ensuring that women and their families have protection against something that has such a severe economic and health benefit for them as unintended pregnancies is a very compelling interest.
But look, with all due respect, that completely avoids the issue. The issue is not whether the government has some compelling interest in making these services available. I mean, we can dispute that all we want, but that's not the issue. The issue is, assuming it does have that compelling interest, can it force the employer to pay for it rather than paying for it out of the government's general fund? And that's where the religious conscience violation occurs, and it's got nothing to do with whether providing contraceptive services to women is a compelling government.
You could say the same thing in the Lee case, and there the court said that when the accommodations would radically restrict the latitude of the legislature, then we start to have a problem, and they upheld it. You could rejigger the situation in Lee as well, and the court declined to do that.
I actually, just to clarify, I mean, I think, John, in fairness, Elizabeth's point is simply, this is a compelling interest in preventing unwanted pregnancies, and let's not make any bones about it. It sort of was oddly muted in the case. But the one important part of that is preventing the incidence of abortion in America, right? Something that everyone on all sides wants to do. That's a big part of the government's compelling interest here. John, that is very much a part of the case, whether the government has a compelling interest. Now, you are saying even if they do, this is not the most narrowly tailored way of advancing it, and then we can talk about that. But in fairness, I do think Elizabeth is responding that the Beckett Fund strongly argued that there was no compelling interest.
Oh, that's right.
Yeah.
But whether or not they do is, I think, irrelevant to the question of the religious claim that is here. Because of the fact that the government could do this directly, this is not Lee. All right? And that's, I think, the core of the matter.
Just a couple things. First, to the compelling interest. The Ocentro case, I think, shows the right way to phrase the compelling interest. You don't say, does the government have a compelling interest in the international combat of dangerous narcotics, right? If that were the way to phrase the question, Ocentro would have not turned out the way it did, which was a unanimous decision recognizing the government did not have a compelling interest in enforcement of the enforcement of federal narcotics laws against the religious claimant. You have to be more specific to the situation. Right, and the court looked at the narcotics laws and the way they were structured and said, no, here the government cannot make out a compelling interest in applying those narcotics laws to this person, which is what RFRA requires. So, yes, we argued that there's no compelling interest in this mandate. We didn't say anything about whether there's a compelling generalized interest in preventing unwanted pregnancies because we don't have to. That's not the analysis.
Right.
That's not what Ocentro says. But just a couple things. To Marty's no mandate point, which, gosh, why did we bring these lawsuits? I thought there was a mandate.
But now that I've convinced you there's not, you'll drop the suits, right?
Wow. Could I step out and call my client? Of course there's a mandate, right? It's in 42 U.S.C. 300 GG-13, right? And it says, health issuers and group health insurance policies shall include the following.
There is a plan mandate. That's not an employer mandate.
Right. There's a mandate, right? There's an HHS mandate that requires these particular preventive services to be included in group health insurance and by health insurance issuer.
And none of them is a plaintiff in the case.
Issuers, yeah. Well, the sponsor of the group health plan is the Green Family and Hobby Lobby. So there is a mandate. Marty's point is that there's an alternative, there's a way out of it maybe, right? And we've always been very clear about this. Hobby Lobby could either eat the massive fine for continuing to offer the non-compliant health plan, or they could exit the employer health insurance game altogether. And as we said in our very lengthy, it wasn't a bare bones complaint, it was a very lengthy verified complaint. If they did that, yes, it had a lot of flesh on it as well. If they did that, they would suffer extreme disruption to their business, to their relationship with their employees, and competitive disadvantages to all the other people who aren't forced to exit the employer health insurance because of their religion, like all their competitors. For example, when Hobby Lobby decided as a matter of fate to close all its stores on Sundays, their competitors rushed in and said, come shop at X because those other guys are closed on Sundays, which cost them millions of dollars. One might expect the same thing to happen if when a potential Hobby Lobby employee showed up and asked about the benefits package and they were handed a brochure that had nothing on it, right? No benefits at all. Or you can go on the exchanges and get your insurance there. Now, it's true, if the government wanted to argue that you have to prove that that is going to be some kind of burden on you, well, we'd be happy to prove it, but the government's never even made that argument, right? The government never contested that there would be a severe burden from any of the consequences of the mandate. It certainly could have made that argument, but it never did. Now, whether there's going to be a remand or not, I don't know. If there is, and the court says, well, go down there and prove it, well, I have to say, I don't think it'll be very hard to prove. But, if for whatever reason we had to, we could. Although the case has never been litigated on that theory.
Let me jump in real quick. I'm going to ask one more question, and then we'll start taking questions from you guys. The issue of abortion did come up in this. Justice Kennedy brought it up. The Chief Justice basically made the Solicitor General say the word as much as he tried to avoid it. And I must tell you, as someone who has tried to write about abortifacients in a way that would not draw complaints for either side, I have not yet found that formula. But one thing that the Solicitor General said, and I can't remember now if it's the Greens that object to IUDs or the Hans that object.
Both, I think.
No, I thought one does.
One didn't
does
say so in
not.
the complaint, but I think by the time of the briefing, they were both saying
Okay,
so.
but at any rate, the Solicitor General said, I don't think that the 2 million women who use IUDs think that they are participating in abortion. And if it seems that the scientific evidence is on that side a little bit. So who decides that? Is it enough that the Greens and the Hans think that that's what it is, and that the government has to respect that? For anyone.
We've got a long body of jurisprudence on not that precise question, but the idea. You can challenge the sincerity of their religious belief, but you can't challenge the merits of it. And if they have a sincere religious belief that constitutes abortion in violation of their religious exercise, and you have to respect that.
I think we actually have some consensus on this too. Just to clarify, the 4 forms of contraception that are at issue in these cases, although I should say in the vast majority of cases that claim that the objection is to all forms of contraception. In these cases, namely Plan B, Ella, and the 2 forms of IUDs, the argument by the Greens and the Hans is that they have a sincere religious belief that the prevention of an implantation of an embryo in the uterine lining is, call it what you will, abortion or anything else, but the taking of human life and doing that deliberately is an immoral act. And I do think the government agrees that we have to take that at face value. Now, that is not the way the law or the medical community describes abortion. It's not an abortion for purposes of abortion exemption statutes and the like, that kind of thing, obviously, or we'd have a big problem with all the women who are using those forms of birth control. But the Greens and the Hans believe that it is, but I just want to be clear on what their claim is. They don't think that every time one of their employees uses one of these forms of contraception, it will result in the taking of a human life. In fact, I think they either concede or they don't argue with the fact that it either will happen extraordinarily rarely or never at all, but there's some risk that one or more of these forms of contraception will, on rare occasions, prevent the implantation of a fertilized embryo in the uterine wall. And so their claim is they want to be able to deny their female employees the right to get cost-free contraception of these kinds because of the risk once in a blue moon that maybe it will prevent, that it will have this kind of effect. Now, I don't mean to say because it's that it's of no moment. They still think that that risk is substantial enough because of the taking of human life, that it's one they don't even want to come close to being in what their view is complicity.
I think,
so I'm agreeing
I
with
think
John on
that's
that. I
right.
just wanted to clarify what
I think I agreed with everything you said, Marty, and I thought it was very fairly stated up until the point where you said that they want to have the right to deny their employees.
Okay.
'cause-
I
right,
apologize. That was another shorthand. We know what our difference is.
That's right. I mean, what
Their remedy would result in their female employees not getting cost-free coverage of these.
Through the employer plan, but not through an alternative source if the government really had a compelling interest here.
That's true.
In fact, their employees would not get this coverage in the same way
If they
that
remained on
Mr.
the Hobby
Lee.
Lobby plan. Yeah,
Yes.
if they remained on the
Correct,
Hobby
yeah.
Lobby.
In the same way that Mr. Lee would not have gotten Social Security
Well, it's not in the
benefits.
same way,
Yes.
but
It is in the same way. The government could have itself provided us all with Social Security, but instead they set up an employer-based plan. Of course, it was an option to have that be a single payer. There, it's an option here for Congress, although
Yeah,
not one that's
Okay,
politically
quick
feasible.
response from Kyle, and then Elizabeth,
Right.
and then we're going to do questions.
Right. So Marty's right about the consensus there, that the specific claim is not about sort of the semantics of abortion.
Right.
It's about the potential action of these particular drugs, right, and the moral significance that the Greens and the Hans put on being involved in providing those drugs, right? So, and interestingly enough, the government, as we said all the time, the government has always conceded that those drugs may act that way. They've always
They
done
may.
so.
They're not sure that they could, but they have not ruled out.
They haven't
that
made
might.
that.
Okay, Marty, that's enough.
Yeah, right.
But so I think, what
Elizabeth,
this
right.
Right. So one other thing, the Greens and the Greens particularly, and I'm sure the Hans too, although they're I'm not as close to them as I am to the Greens. They're not objecting to what their employees are doing.
I agree.
They're objecting to their own forced participation in what their employees are
agree with
doing.
that.
In the same way that Mr. Thomas and Thomas versus Review Board was not necessarily objecting to the soldier in the tank in Vietnam who was firing the shell. He was objecting to his own participation in producing the tank.
But
which is an
Elizabeth, there are
important distinction.
cases that are coming or are out there in which it's an objection to all contraception.
Well, I
Correct.
think I want to stay on the point that you raised before, because I think what the Solicitor General was doing by reminding the court about the women who use copper IUDs, not thinking that they are engaged in abortion, it was trying to sort of bring back the employee-focused argument here, and to show that it's important that you have the full range, because if you don't have cost, a lot of people think, well, Scalia even said, well, it's not that expensive, just let the women pay for it. But the reality is that IUDs in particular have a very expensive upfront cost, and they are often the safest and most effective, particularly for women who've already had children and might want to just control their family size. And I think by bringing it back to the employees and their families and their decisions with their doctor, what the Solicitor General is trying to do is to get at the point that Justice Kennedy made, which is that the employees do not leave their own religious beliefs and exercise and choices at the door, particularly when they go to work for a for-profit, not explicitly religious corporation. The expectations are just different than when you work for that sort of corporation as opposed to an explicitly religious corporate form. And that distinction has gone back to the time of the founding and Blackstone's distinction between lay and ecclesiastical corporations.
Okay. We'll open up for questions from you guys. I see there's a microphone. They would probably like you to use that because millions of people are watching this on the web.
Hi, I'm Andrew Cluster with the Heritage Foundation's Legal Center, and my question,
Might not be working.
Oops.
See if
Is it on?
it looks like it's on.
Do we have a technician in the house?
We can hear you.
Okay,
anyway.
talk real loud.
You can hear me. Okay, so oh, there it goes.
Now it's working.
I want to hear your thoughts on an issue that you punted. You all agreed, said Professor Lederman, that the court will reach the merits, and that's great, but at least two of you are in the public square sort of pulling a Citizens United and sort of in anticipation of the decision, politicizing it. You really shouldn't issue a decision here because a corporation can't exercise religion in the same way an individual can. So My question is, because Professor Eastman mentioned something that I thought was interesting. My question is, in a world where the court issues a Lederman Wydra decision and says no standing here, would
in fairness,
Sure.
that's not my view.
Oh, I apologize then. But okay, in a world where that
And
does
it's not really my view either. It's the founders.
okay, so you all
All right,
agree.
somebody will, though.
No, I think it's right, but I'm just saying it's not political. It's just based on constitutional text and history and what the
Well,
founders
then-
said. So.
Sure. My question then is, in a world where they apply that sort of standing doctrine, wouldn't that? I guess my question, and it's also for Professor Eastman and the rest of you, would that impliedly overturn some of these Establishment Clause cases? And could you get maybe direct subsidies to the Catholic Bishop of Chicago, a corporation sole, for religious purposes, or in the harder case, for administrative purposes? And money's fungible, and now they have all this additional resources.
Okay, who wants to go first?
Yeah, I mean, they're analytically distinct cases, the Establishment Clause cases and the free exercise cases. I made the point because we never asked the question in those establishment cases whether the fact that the money was being expended by a corporation meant that it was not exercising religion, and it was because it was exercising religion, that led to the Establishment Clause came. So I think you can't have it both ways. And I'll broaden it. Amazing that a large number of the people that are arguing that a corporation can't exercise a religious conscience are the same people that routinely insist that our corporations exercise a social conscience. I saw in the paper this morning, Stanford's just kind of divested itself from coal, right? Stanford, a major corporation, has decided to exercise its corporate responsibilities and exclude itself from. Well, you can't have it both ways. There's not a subset. Religious conscience is a part of overall conscience, and we expect corporations to exercise that all the time. I don't know. This argument that they can't is entirely new, and I think it was designed to try and figure out a way to avoid getting to what I think is a fairly clear-cut RFRA violation.
Marty or?
Yeah, I'll just use this as an opportunity to broaden the lens a little bit, because I saw in the description of our panel that it was also about broader religious issues in the court. Obviously this week they decided the Town of Greece prayer case. I don't think so. One thing that's really interesting is when Justice Alito replaced Justice O'Connor, I did a series of blog posts explaining that I thought it was the most substantively important change on the court in several decades. It would change the most doctrines, and I identified 5 constitutional doctrines in particular that I thought would change quite rapidly. 3 of them have affirmative action, abortion, and campaign finance. One of the other 2 was Establishment Clause law, and in particular, I thought that the whole line of what you might call Everson through Lemon through Mitchell versus Helms funding cases were at stake. And interestingly, though, since Mitchell, there haven't been any such cases, and I don't see any in the pipeline. There's no circuit splits that are brewing to get that up. But this court is really interesting. Early in the panel, John said, I wrote it down here. It is the free exercise clause has always been broadly interpreted. Boy, that's not my understanding of our national history, right? Except for Yoder and Sherbert, it's always been very narrowly interpreted. One thing that's very interesting, that Justice Alito in particular, but I think other justices as well, are much more sympathetic to religious liberty claims than many justices have been since Justice Brennan, who was the last one who was such a strong pro-free exercise justice. I don't think Justice Scalia is there, if his Smith opinion is any indication, but Justice Alito very much so. I don't know quite where the chief is. And on Establishment Clause, obviously there's going to be major changes unless there's a change on the court. If this court continues these 9 justices for a long time, I think it's pretty clear that they are much less sympathetic to Establishment Clause claims than any court has been in my lifetime. And so I think in terms of general trends, you might be seeing a move. The Warren Court was basically strong free exercise, strong establishment. You might be going, and then the Scalia-Rehnquist Court, you might call it, was weak free exercise, weak establishment. We might be moving towards strong free exercise, weak establishment. I think only time and appointments will tell.
Anybody else? Yes.
No, I just want to ask Professor Lederman and Ms. Wydra to comment on Professor Eastman's observation about corporate conscience. Do you agree with what he was saying? Or
I think that's a clever rhetorical point, but we're talking about constitutional rights, and they're, I don't think anyone is suggesting that there's a constitutional commandment that corporations exercise a social conscience in the way that we're talking about divestment and so forth. If you look at the text and history, which is what I am guided by when I look at these cases, then you see a very different treatment of explicitly religious corporations, of people coming together to exercise their religious beliefs through the explicitly religious corporate form, and commercial for-profit enterprises. Even if they're helmed by people who are themselves devoutly religious, 2/3 of Americans consider ourselves to be very religious people, but that doesn't automatically transform every endeavor into sort of, act of the church.
And I already gave my view. I'm not sure whether corporations ever can, but I think the real issue here is whether the Hans and the Greens as corporate directors can, and I think the court will say yes.
Go ahead.
Hi, Kathy Roos, Family Research Council. Just a question about compelling government interest. If providing free contraceptives to women or free contraceptive coverage to women would be a fair way of talking about the compelling government interest of the government, then why is who's providing it? If who's providing it is not part of the compelling government interest, then why isn't Title X provision of these things clearly the least restrictive means? But if it is from your employer, free coverage from your employer, if that's the argument, and if that's part of the compelling government interest, but so you don't admit that that's part of the you say no, it's this broader free contraception for women government interest.
Put a little narrower. Free contraceptive coverage from your health insurance plan, no matter what the source of that plan is.
So
Okay, so whether it's employer-based or not.
what if the government could give credits or refunds?
The government could, but the system we've set up is one in which these preventive services, not just contraception, are all going to be provided. All individuals in America are going to get these minimum coverages from their health insurance plans. That's what Congress has decided is the most efficient and effective way of dealing with the provision of health care.
So you are saying that the compelling government interest is that free contraception from your employer if
No,
you
from
work
your
from
health insurance plan. From your health insurance plan. Most people will get it from a plan bought on the exchanges or Medicaid or Medicare. From your health insurance plan, no matter what the source of your health insurance plan is. But you're raising an interesting point, right, which is suffused the argument, which is we've talked in terms of compelling interest and narrow tailoring. And here's the oddity of this whole thing. And this was, at oral argument, this was the thing that surprised me the most. RFRA is intended to reincorporate as a statutory matter the Free Exercise Clause doctrine. Part of what Justice Scalia said, the central thing that Justice Scalia said in the Smith case, in which they abandoned their quarter of a century of this, was, we've been talking a good game for 25 years. We've been talking compelling interest, narrow tailoring, and we never apply it that way. We don't apply it the way we do in the free speech area, in the equal protection area, and the like. We are not. We're basically applying a slightly heightened form of rational basis scrutiny to denials of religious exemptions, but we're calling it strict. We're using these phrases that are strict scrutiny. Everyone has assumed, or not everyone, most people, most of us who have worked on these issues over the years have assumed RFRA incorporates what the court was doing, not what it was saying, that it's not really a strict scrutiny test, that it's this kind of in-between, intermediate kind of thing that was going on, even though RFRA repeats the language of compelling interest, narrow tailoring. What was really interesting is that Justices Alito, Scalia, and the Chief seemed to be saying, RFRA isn't, I don't want to hear what the court was doing under the Free Exercise Clause all those years. RFRA itself changed things dramatically. They've asked us to apply strict scrutiny, something we weren't doing before. Stop citing me the cases from before 1990. I don't think there were 4 or 5 votes for that, but I thought it was incredibly striking that at least 3 justices were of the view that, hey, Congress inadvertently did something really radical in 1993 and increased the government burden substantially over what it was before 1990.
Kyle, what do you think?
Well, I did see that kind of cleavage on the court,
Yeah.
Marty, where and Scalia even said, well, and Congress added a least restrictive means component to our previous test. And then on the other side, I mean, I haven't been working on these as long as you have, but I was surprised at the sort of forthright way that Justice Kagan was saying, well, you can't possibly be asking us to apply strict scrutiny here.
Which is what Justice Ginsburg was saying to here, too.
Right,
no
right.
member of Congress thought
Yeah,
this.
yeah,
right?
and except for the words that are right there in the text of the statute, right? But the other thing is that the House and Senate reports are a little bit sort of ambiguous on what Congress wanted. They, as you know, I mean, they say, look, we're intending to restore the compelling interest test as it was applied in Sherbert and Yoder, right, which were, people say, the high watermark of the way the court was applying the test, very powerful. And then in other parts of the House and Senate reports, it says, and look, we're not intending to endorse any particular result in any particular cases. You know, those cases should be a guide, but we're not rubber stamping the whole enterprise. So I think the legislative history is a little bit ambiguous as to what Congress thought it was doing, which is probably just the result of the sausage
I'm not sure that's
factory.
right. I think there was a general consensus they meant to be incorporating the whole corpus of jurisprudence up until then. And it's a really interesting legislative history. You guys will all be interested in this because the impetus to doing that, to making sure this was not read more broadly, was coming from overwhelmingly the pro-life members of Congress, Henry Hyde and Charles Kennedy and the like. And why? It's a really fascinating dynamic. At the time, they were afraid that the court was about to overrule Roe versus Wade, that Congress or state legislatures would come in and start prohibiting abortion, and free exercise claims would start to be made by women under RFRA to get abortion rights after the court and the legislatures had denied abortion rights. So it was the pro-life Republicans who put all this legislative history in, saying all this does is reestablish what the court's doctrine was pre-Smith. And it just goes to show on these things that from decade to decade, you know, don't be too certain what the doctrines that you're asking for now, how they're going to cash out 20 years later.
Very quickly, reporters don't make predictions on how cases come out, but they do ask people to make those predictions. So we'll go very quickly and tell me if you saw something very narrow coming out of this thing, or if you saw something broad and how you think it's going to go. Time's up.
Okay, I think a very wide consensus, 8 or 9 justices are going to find that either Hobby Lobby or the Greens or both of them have the right to bring a RFRA claim. That seemed pretty clear to me. On the merits, I mean, you know, it's hard to read tea leaves from oral arguments. I thought the majority of the difficult questions went against the government, although our side got some difficult questions too. So I'll just be conservative and say 7-2 for the Greens and Hobby Lobby. On the merits. And no remand. We don't need a remand.
I think just because of the politics of it and the lingering politics of Citizens United, which is another First Amendment clause that continues to be a source of great friction, I think it's 5-4, but I think Hobby Lobby wins.
I think on the so-called threshold question, I hope it won't be on the corporate question, but on the Greens, I think I agree with you guys. I think the court overwhelmingly, if not unanimously, rules against the government. On the merits, it's either 5-4 one way or the other, or I think there are one or the other of these, or both of these 2 grounds for remand and kicking the case until maybe one of the nonprofit cases gets up before the court in the next year or 2.
Elizabeth?
Yeah, you know, I think that there did seem to be appetite from the justices to reach the merits, although I wonder if when they actually sit down to write it, if the sort of newness of what they're recognizing will strike them, or the Pandora's box of corporate law issues. And I think on the merits, it's hard to say. You know, Justice Kennedy did seem concerned about the employees' interests and the government's compelling interest in protecting their statutory rights. So, close call.
All right. Well, I'd like to thank the Federal Society for putting together such a terrific and knowledgeable panel. It made my job very, very easy.
And thanks to Bob for
Yes, thank you. Bravo.
Thank you.